I see the same three mistakes that California employers make over and over that lead them to being sued by their present or former employees. So here are these three mistakes to avoid. Number one, firing an employee without evaluating first whether that employee would be able to make it look like they've been terminated for unlawful reasons, even if you, the employer, think that they're being terminated for perfectly lawful reasons. Example, you have a worker who has been late 3 days in a row to report to work, 10 minutes each time. And you're terminating them for tardiness, but that worker happened to file a workers' comp claim a week earlier, or he requested medical leave, or he complained about sexual harassment a week or two earlier. Are you going to be able to prove that the reason you terminated that worker was because of that relatively insignificant tardiness and not because of those complaints or those requests that he made, in which case it would be unlawful? It is a much better idea to evaluate this before and not after you fire that employee. Mistake number two, misclassifying employees as contractors. I still see so many employers not realizing that just because they call a worker a contractor and they even have that worker sign an independent contractor agreement where that worker agrees to be a contractor, this still doesn't mean that that worker is an actual contractor under California law. What matters is not the label, but the degree of control that your company exercises over the manner in which that specific worker performs his job. And number three, misclassifying workers as exempt managers from overtime. Just because you call your employee a manager and you gave them the title of a manager, this doesn't make them a manager if they don't meet certain criteria and certain requirements under the law. You should evaluate whether you're able to correctly classify any of your workers as exempt with an attorney as early as possible to avoid significant liability for unpaid wages and overtime, especially if the employee in question frequently works more than 8 hours per day. Again, what matters in many of those issues of misclassification is not what you call the worker, is not what you agree with that worker for them to be, but the facts and circumstances of their day-to-day employment and their day-to-day duties. Thank you.